Good afternoon, Your Honor. Jason Irvin on behalf of Procarza USA and Procarza Tube and Pipe.
Let's proceed.
Good afternoon, Your Honor. We have before you here today a motion to compel. We are seeking three rulings overruling the objections that the defendants Procarza USA and Procarza Tube and Pipe have made to Blue Racer's discovery requests, as well as orders for Tube and Pipe and USA to fully respond to our request for production and our interrogatories, as well as provide a verification for the interrogatories. And then finally, a request that the USA and Tube and Pipe entities produce corporate representatives for depositions prior to the end of this month, so by March 31st, 2022. Is there a particular place where you would like me to start, Your Honor, or are you good for me just to go straight through?
Go ahead.
Okay. Your Honor, earlier in November of 2021, we served discovery requests onto the defendants Procarza USA Inc. and Procarza Tube and Pipe. This case arises from a pipe rupture. The Procarza USA entity and the Tube and Pipe entity were initially brought in thinking that they were either sellers, importers, exporters, or manufacturers of that pipe. We have since learned that there are other entities that were potentially involved in the manufacture or sale or licensure or testing of this pipe. And so we sent discovery requests to figure out the proper roles and what each of these entities that had already been served and brought into the case had with this pipe and with potentially its rupture. The defendants who were served, who have appeared in this case, are the USA and Tube and Pipe entities. They're both Texas entities. Blue Racer has also served another Mexican entity called Procarza Tuberias, and that entity has filed a special appearance, which they filed last week. And there's also potential for another entity called Procarza Industrial to be entered in. Seems that there are a lot of related entities with similar names, so we're a bit confused on who's doing what and who was involved with which portion of this pipe. Now, with regard to the request for production, the defendants lodged the same 4 objections to each of Blue Racer's 29 requests for production, citing vagueness or overbreadth or irrelevance, and at the same time produced no documents. We received document production on Thursday of last week of about 400 documents, 90 from the Procarza USA entity and about 350 from the Tube and Pipe entity. These documents were responsive to some of the requests that Blue Racer had lodged on these defendants, particularly requests number 10 and 12, we believe have been satisfied. However, we maintain our request for our motion to compel on these requests since the remaining 27 have no documents that are related to it, and yet they are still maintaining their objections. To the extent that either entity claim they don't have any documents, we understand that. We would just request that they remove or withdraw their objections so that we can be sure that no documents are being withheld on the basis of those objections. And additionally, there are a couple of requests, specifically 10 and 12, that we believe are satisfied, but just to make sure, so we are dotting our I's and crossing our T's to withdraw those objections or to at least let us know if there are any documents being withheld on the basis of those objections.
Response?
Yes, Your Honor. May it please the court, Jason Irvin on behalf of Procarza USA and Procarza Tube and Pipe. This case has been a labor of love for me because it's been difficult to figure out who the correct entities are and to get information from them because they're Mexican entities. Ms. Smitherman is correct that we produced documents which took us a long time to collect and send to them, but I will provide updated discovery responses from those 2 entities as it relates to the issues here, because Procarza USA, which she has 90 pages of documents evidencing this, was created after the incident in question happened, after the pipe was sold, a year after the alleged pipe failure. And so to me, it's a rifle shot issue, which is they didn't exist, they couldn't have been involved. Procarza Tube and Pipe is a mere importer who was the conduit from the sale from a Mexican company, Industrial, to Steel Professionals, which was a US company, who modified the pipe and sent it to Ms. Smitherman's client. We've provided the documents responsive to 10 and 12 because those are the documents, the sale documents, in which Tube and Pipe has responsive information. And so as I admit and I state very candidly in our response, we owe her amended discovery responses. Are going to get those to her. I have no problem with that. The issue that I take here today is with the deposition request, because USA did not exist and she has documents that evidence that completely. And I've told Ms. Smitherman, USA, you have paper that says they don't exist. And I have offered you to say to you, dismiss this client and I'll give you a tolling agreement. So if you find out something different down the line, you're not prejudiced to bring them back in. All indication that I have is that that company will never come back in. And so there's no call for a deposition for them. With regard to Tube and Pipe, they have the documents. They're going to get our amended discovery responses. I am drafting them as I speak for client review. But getting the documents from a Mexican company who doesn't understand the tort system here, and figuring out the right company has been a challenge. And I have candidly, Your Honor, prioritized trying to find out who the right company is and tell them that. And they're not playing Charlie Brown in the football or go fish. Hey, you've got the wrong company, go look again. I've tried to be very upfront, as I believe I have an ethical obligation as a member of the bar to say, not only is this the wrong company, but here's the right company. So I've given them documents. I've told them that information. I want to get them updated discovery. But I believe the deposition request is premature because we have to bring in Industrial, the manufacturer, the one who specified that this pipe would meet certain requirements. At least I believe. I've not been in contact with them yet, but that's the information I have. And then we also have to bring in the second manufacturer that altered the pipe, Steel Professionals. And once we get the right parties in this case, this is why I asked the court for an April 2023 setting. We get the table set for the right parties. I think we can conduct meaningful discovery. But, as I mentioned, I will fall on the sword. There has been some difficulties getting documents. I have those now, giving those to the plaintiff's counsel. But I simply ask that the court delay this motion for deposition until we can get those right parties in the case and they can serve those correct parties. And then we can conduct meaningful discovery in this case.
Response?
Thank you, Your Honor. Mr. Irvin got a little bit ahead of me. I was just going to go for the request for production, then go into the rogatories and then to the depositions, but I'll kind of jump around. I appreciate Mr. Irvin stating and all the work that he has done. I understand this has been very difficult to clear out and figure out who has been working. So I wanted to thank you for the work I know that you have been doing and your candidness and your communication with us. We really appreciate that. With regard to the depositions, we noticed these depositions at the beginning of February. No motion to quash, no motion for protection came through. I showed up at counsel's offices and apparently there had been a miscommunication either regarding the fact whether or not those depositions were going to continue or what date they were supposed to be on. However, it was made very clear to me that no witness was prepared to be produced to us. And so we actually ended up canceling the deposition that was scheduled for the next day. And as to the objection of these depositions being premature, that's not a valid objection to a properly noticed and unquashed deposition, especially for a corporate representative. At this point in time, we have no answers under oath from either Tube and Pipe or USA regarding their status. We understand Mr. Irvin's position regarding USA and its potential non-existence during this time of this incident. All we seek is a verification or some type of explanation under oath regarding their entity and their existence. The reason we were actually proceeding with the depositions because we figured it would be an easier way to get the answers of who these entities are, when they were formed, what they do, what their relationship is to one another. For example, attached to
I get it.
Okay. Yes,
I'm going to go ahead and grant the plaintiff's motion to compel the defendant's motion to compel plaintiff's motion to compel in its entirety. Do you want to go ahead and pick a date for these depositions to occur?
Sure, Your Honor. Let me look. Jason, Mr. Irvine, are there any dates that particularly that work best for you? I know it's been difficult for you to get contacts with your client because I know while they're based down in Brownsville and the Woodlands, a lot of them live in Mexico. I'm free the last week of March. As long as we can get a date down today, I'm not particularly worried about when they happen. So whatever works best for you, Mr. Irvine.
I appreciate that, Ms. Smitherman. My concern is that the witness at issue lives in Mexico. And so these entities that would testify live in Mexico. So I need to bring them to Brownsville, presumably for a deposition. There is no operations in the Woodlands for tube and pipe right now. So that is the difficulty here. I understand the court's ruling and I won't quibble with it. I've done this long enough to know that that's not wise. But I would ask Ms. Smitherman if you would work with me, give or take some time. I understand the court's ruling sometime either the last week of the month or the first week of April. I would appreciate that.
Why don't we just do this? Let's include in the order that the depositions are to take place within the next 30 days.
That's perfect, Your Honor. I can update. I filed a motion stating by March 31st, but I can file an amended motion or amended order stating within the 30 days of the signing of the order.
So another thing I want you to do in the amended order, I want you to share it with Mr. Irvin. Make sure that it says at the beginning that this hearing was heard on March 7th, 2022. I guess you've seen me do this before, not on this day. And get that submitted to me as soon as possible. Make sure you share it with Mr. Irvin. And the location of the deposition, Ms. Smitherman, are you opposed to going to Brownsville to take these depositions?
We would prefer them to be in the location of the form of suit, if at all. That would be our preference. But Your Honor, if you would,
Mr. Irvin, do you have offices in Dallas?
Yes, Your Honor. We have offices in Dallas. I'm sitting in Dallas speaking to the court. My concern was I've got to get a witness to travel internationally. And what I don't want to do is set myself up for failure and find myself back in front of the court, having disappointed both the court and Ms. Smitherman. So that's why I was trying to choose Brownsville as a quick Southwest flight. And it increases my odds of success. I'll put it that way.
Ms. Smitherman?
And unfortunately, this increases the cost for my client when they were properly noticed prior to. But we will defer to your judgment, Your Honor.
But it's going to take place in Dallas unless there's an agreement otherwise.
I understand, Your Honor.
Why don't you guys do this? Why don't you? I'm going to order it to occur in Dallas within the next 30 days. If you guys want to agree to something else, I'm perfectly okay with that, Ms. Smitherman. I will just say I've seen this dynamic before, and it might be, you can be penny wise and pound foolish. I don't know if you're too young to remember that saying, but that's maybe dating myself. But it might be in your client's best interest in the long run to try to work with them to try to get a location. There are some issues with crossing the border right now with COVID and other issues. I know that I was in El Paso recently, and there was a discussion about how difficult it is to go back and forth across the border right now. And so there might be some limitations for it may just end up being a lot easier and cheaper to do this in Brownsville than it would be to try to do it in Dallas. But if you can't reach an agreement to that and you decide you want to, draw the line in the sand, I think you're right on the law. And so we'll order it to occur in Dallas.
Thank you, Your Honor. We'll having the order, having it occur in Dallas is very helpful for us. And we will, of course, work with you, Mr. Irvin, to make sure we can find something that will lead to success.
And I will say, Your Honor, that while we're in front of the court with a disagreement, I credit Ms. Smitherman for not being disagreeable. I think we've, we may disagree on some points, but I think that it's a pleasure working with someone who's very professional. And
likewise, Mr. Irvine, thank you.
You guys have been, I wish all of my hearings were as pleasant as this one. You guys are a credit to the bar. So thank you for your
Thank you.
We
professionalism.
appreciate that.
And,
One final housekeeping thing, Your Honor, and I've spoken with Mr. Irvine earlier this morning on this regarding our mediation date. Currently, that mediation date is set for March 18th. We intend to, we're perfectly satisfied with the court's choice for King Fife as our mediator, but want to update the date to a date that will work better once we have discovery going. Just wanted to see with you how best we can present that to you.
I don't really
Notice our
care.
motion.
As long as you do the mediation prior to trial, I don't really care.
Okay.
When's your trial setting?
It's in
It's
April 2023, Your Honor.
Yeah.
okay. We'll just file a joint notice for showing the date that we'll set for a mediator.
Sounds good, guys. Thank you so much.
Thank you, Your Honor.
Thank you for your time, Your Honor.
Thank
Can we
you.
be excused?
You may.
Thank you.
Let's see if this next group of attorneys will be as agreeable and professional. All right, I'm just kidding. All right, everyone here for the Hill case?
Rodney Gappelberg here for the plaintiff, Your Honor.
Sid Murphy for Arlington Ophthalmology and the Kleiman defendants, Your Honor.
Ryan Trammell here for Dr. Hines.
My name is Greg Bird. I'm here for Walnut Hill Surgery Center and Greenville Surgery Center.
Liz Strum for Dr. Abishagar.
Ricky Hirschman for Sai Shivala, MD.
Let's go ahead and get started. We're going to go on the record on cost number. I just had all of you guys announce yourself. Is everyone here? I guess is my main question. Are we missing anybody?
I believe we're all here, Your Honor.
Okay. Everybody got here early, which is always good. So let's get started. Let's go on the record. Tony on cause number DC 21-10661, Norbert Hill versus Arlington Ophthalmology Association, PLLC. At all, counsel, make your appearances.
Rodney Gappelberg here on behalf of plaintiff Norbert Hill.
Sid Murphy on behalf of Arlington Ophthalmology, DBA Kleiman Evangelistic Eye Center, and all the Kleiman defendants, Your Honor.
Ryan Trammell here on behalf of Dr. Mujahid Hines.
Greg Bird here on behalf of Walnut Hill Surgery Center and Greenville Surgery Center.
Liz Strum on behalf of Nora Abishagar.
And Ricky Hirschman on behalf of Sai Shivala, MD.
Okay, let's get started.
Your Honor, I don't know who's going first, but I'll be happy to start if you'd like for me to.
Go ahead.
All right, I represent Arlington Ophthalmology. And as the court knows, this is a healthcare liability claim that is governed by Chapter 74 and specifically Section 74.351 RS or R6 is the section that we're here on because plaintiff has provided a purported expert report from his expert, Dr. Berkowitz. And we believe that that report is insufficient under Chapter 74.351 R6. The basic requirements, as the court knows, are that it must provide a fair summary of the expert's opinions regarding standards of care, how the manner in which those standards were breached, and a causal connection between the manner in which the standards were breached and plaintiff's alleged injuries. There's another requirement, and that is that the expert must be qualified. And we have made an objection on that basis as well, because Dr. Berkowitz has not provided this court, either in his CV or in his report, any indication of his qualifications to testify as to the standard of care for an entity or a surgery center. And therefore, he's not qualified to testify or render opinions to the court for Arlington Ophthalmology, DBA Kleiman. And I'm just going to say Kleiman because there are like 4 defendants.
Okay. So I read your argument. It's kind of a unique one. Who would be qualified to testify about the standard of care for a center then? I've never heard the distinction made because it's an entity and not an individual.
Well, if you look at his report, Your Honor, he talks about sterilizing equipment. And I'm going to get to that because he does so in a conclusory manner. But someone that's responsible for sterilizing that equipment, he doesn't tell the court that he has any experience in what's involved in sterilizing equipment, how it's done, when it's done, what the process is, any of that type of thing. And I would think someone that has experience in that field, someone that works with sterilizing equipment, knows the equipment, knows how instruments are sterilized, all those types of things. He may actually know that, but we're confined to the four corners of his report, and he gives the court no indication that he's got any experience whatsoever in that area. And that's the basic objection. Excuse me. And if we look at his report in detail, he goes on for roughly 7 pages with the facts of the case as he summarizes them. But I can narrow our objections to pages 8 and 9 primarily of his report. Specifically at the bottom of page 8, he says the standard of care to be followed by nurses, technicians, and other providers of Kleiman and or Walnut Hill, so we don't really even know who he's talking about, who participate in the cataract surgery by way of assisting Dr. Hines. So, Your Honor, I think that answers your question. Someone who's got experience in assisting the surgeon. He doesn't tell us that he's got any of that assistance or any of that experience. And he says the standard is to prevent contamination of the interior of the operative eye by providing a sterile operative field, adequately sterilizing all instruments, devices, tools, and other equipment actually used during the surgery when the integrity of the eye is invaded. That's his opinion with regard to the standard of care for Arlington ophthalmology. He then goes on with regard to Dr. Hines, and in just 2 sentences later, he says the failure to utilize sterilized surgical tools, ensure a sterilized operative field, and or sterilized equipment and solutions during the surgery can permit an invasive bacterial organism entry through the surgical wounds into the aqueous and or vitreous humor of the eye, thereby permitting an infection. He does not, if we look back at the statute, it specifically says the report must provide a fair summary of the expert's opinions as of the date of the report regarding applicable standards of care. Now, arguably, he's done that, but it's very broad, very conclusory. But here's what he hadn't done. The report must also state the manner in which the care rendered by the physician or healthcare provider failed to meet the standards. All he does is say, here's the standard, they violated it. He almost works backwards if we look at the rest of the report. Going to the top of page 9, he talks about Dr. Hines placed a lid speculum, and he states that the incision was checked and found to be watertight. And he states that there is a recognized but low incidence of post-surgical infection following cataract surgical patients, but they are rare. And then as he concludes his report with regard to causation, he simply says violations of the standard of care by Kleiman, its nurses, technicians, associated operating room personnel, and he goes on and on and on, but basically says violations of the standard of care altogether caused an infection, which is serious infection of the interior of the eye, ultimately caused a loss of vision, etc., when surgical instruments, tools, and supplies were not properly disinfected. He says could, can, did, and all he says is, hey, in a conclusory fashion, they didn't disinfect all these instruments, but he does not say one word about the manner in which they were supposed to disinfect these instruments. He simply concludes because he had an infection, they must not have been disinfected. And that is an insufficient expert report. And frankly, the way that it's worded and he reaches those conclusions really isn't a good faith expert report, because he does not give this court any iota of what they were supposed to do, how the manner in which they were supposed to do it, and how they failed to do it. And that's the basis of our objection, Your Honor.
Thoughts?
Your Honor, the objection that was alleged, as I read it, was to the qualifications of Dr. Berkowitz. There were no objections to his enunciation of the standard of care or causation with regard to Kleinman. However, regarding the objections that were made in the written objection, as reported by Dr. Berkowitz, he's performed over 10,000 of the same exact surgeries that Dr. Hines and Kleinman performed on Mr. Hill. He stated in his qualifications, he has decades of professional experience in providing the same medical services rendered by those providers. He treated Mr. Hill in his August 9 surgery. He's very familiar with the standard of care required by the surgeon, by the staff who assist the surgeon during the surgery, for the clinic or ambulatory facility where cataract surgery and retinal surgery is needed. It goes on and on. I think it's pretty clear in the law, Your Honor, that as long as the expert professes knowledge and familiarity with the standard that is involved in the lawsuit, that is sufficient. He can be from a different specialty of medicine. I'm not really sure, like the court apparently, what specialty of medicine Dr. Kleinman is referring to. An assistant for an eye clinic during a surgical procedure. We're talking about unsterile instruments. It is alleged was a possible, most likely probable cause of the infection. I certainly think a surgeon who has performed 10,000 plus of these surgeries is qualified to comment on whether or not aseptic techniques were utilized. This is early in the proceeding. Discovery hasn't yet even commenced. It sounds like that Kleinman is also objecting to the fact that Dr. Berkowitz hasn't gone through every protocol and procedure required to properly sterilize something. We don't think that's needed at this instance. He's well qualified as an eye surgeon. He's got years of experience, thousands of similar procedures. He performed surgeries still at an eye clinic and previous eye clinics. I think he's well qualified as the objection was lodged to comment on the personnel and the method that apparently unsterile instruments were utilized.
Objections overruled. Anybody else have an objection?
Your Honor, I would like to go if you don't mind.
Go ahead.
Your Honor, Ricky Hirschman for Dr. Shavala here. In our motion, in our objections to Dr. Berkowitz's Chapter 74 report, we're merely objecting to the causation opinions that he offered in that report. He wrote a 14-page report, and about 3/4 of a page was given to causation in this case. And as you know, causation opinions cannot be conclusory statements, and they can't be based on mere speculation. In other words, he can't simply say, because this surgery happened and then this infection occurred and then Mr. Hill lost his eye, then all of the care in between that I think breached the standard of care must have caused that. That is a conclusory speculative statement, which is what his 3/4 of a page of causation opinions are. His number one mistake is that he lumps all of the defendants together in his conclusory statements, but each one of the defendants treated this patient at different times. So all of their care couldn't have caused all of these issues. For example,
Ms. Hirschman, let me ask you this.
Yes.
Did your doctor treat, was he involved or she involved in the surgery?
He was not involved in the initial surgery. No, Your Honor.
Where the sterilized, or allegedly unsterilized equipment was used?
No, Your Honor. He was not involved in that. My doctor got involved in the care and treatment after the infection at issue was already present. And one of Dr. Berkowitz's opinions is that my doctor caused that infection and the need for the surgery that my doctor performed. He could not have caused either of those because he was not part of this patient's care and treatment until after the infection was there.
Okay. Mr. Gappelberg?
Your Honor, I've alluded in the response that I filed that Dr. Shavala's participation is somewhat akin to the last clear chance doctrine that we heard of many years ago, but not recently. He was called upon to try to close an unsealed wound created by Dr. Hines when endophthalmitis had purportedly, which is a condition caused by a bacteria that was introduced during the surgery. Within 3 days.
If he wasn't involved in the surgery, how could, I guess you're not alleging that he caused the infection.
I think he worsened it. The purpose of his treatment was not only to close a surgical wound, but to provide 2 necessary antibiotics, one of which he did not have, one of which he claims he could not obtain. So he went ahead and did the surgery, even though his records say the standard of care requires both.
The subsequent surgery.
During the subsequent surgery.
Ms. Hirschman, can you share screen the portion of the plaintiff's report that addresses your client?
That may be.
Yes, Your Honor.
Oh.
One moment.
I think it's page 13.
It is. Just trying to pull up the right screen here. Let me make this bigger.
I think that's 14, Ms. Hirschman.
This is 14. You know what? Let me just do this real quick. Sorry, Your Honor. Let me just unshare and then reshare here for 1 second if I can. Because that one's online, so it's not going to show up as well.
Okay. Mr. Byrd, are you doing okay?
Doing well, Your Honor. How are you doing?
I'm doing well. You just have a concerned look on your face. Want to make sure you're okay.
I'm very stressed by this hearing, Your Honor.
I'm sorry. Well, hopefully I'm not making it too tough on you, not yelling at you for shuffling your notes or anything.
And I appreciate that.
My understanding is he's not even a part of the hearing.
Well, then he shouldn't be stressed at all. All right, is this
Your
it?
Honor, this is page 13 is the standard of care opinions, and then page 14 is the causation opinions pertaining
Okay.
to my client.
Your
So
objection
we'll
to let me see the causation. You're objecting, that's what you're objecting to is causation, right?
yes, Your Honor.
Let's see.
Specifically, it starts right about
I see
Dr.
it. Yeah.
Shavala.
Yeah, I don't think this is sufficient. I'm going to order you to make this more clear because I don't even understand what Shavala did wrong here. I guess he referred him to someplace that didn't have the antibiotics. Is that what the?
No, he did the surgery himself without providing both antibiotics.
Oh.
even though he said they were both required. And he ended up losing the eye 3 days later. So Dr. Shavala had the means to hopefully correct the ongoing infection, but by his own records, he failed to provide the standard of care, and as a result, blindness and enucleation resulted.
Ms. Hirschman, let me just ask you this. I mean, I'm not going to dismiss this case, but if you feel like you need, I don't think this portion of the report is a model of clarity. If you want him to have an opportunity to supplement it, I'll allow that. But if that's not helpful to you, then I'll just go ahead and deny it.
We would like for him to supplement the expert report. There's no any sort of explanation as to why administration of the antibiotics would have made a different outcome here. There's no explanation whatsoever other than he didn't give the antibiotics. This guy lost his eye. The infection was already there. The infection was already bad enough that we had to take him to an emergency surgery. So our client is seeking clarification on what this expert's opinions are exactly regarding causation.
I think that's fair, Mr. So I don't see these very often. Is it still, I know the law changed at one point. Is it still 30 days? Is that how much time he has, or is that law changed?
Still 30 days, Your Honor.
Okay, so you have 30 days to,
as far as I know.
30 days to supplement the report as to that point. Anyone else have an objection that they still want to make?
Your Honor, this is Liz Drum for Dr. Noor Abishagar. We had the same objection as Ms. Hirschman very eloquently put in her argument. We had the same objection to causation. With our client, it is unclear what.
Ms. Hirschman, can you share screen again, that portion? Who's your client again?
Dr. Abishagar.
Let me take a look.
Here we go.
Thank you, Ms. Hirschman.
You're welcome.
How do you say it? Abishagar?
That's correct, Your Honor.
Your Honor, right, if you could see my cursor, it starts about right here, I believe, for Dr. Abishagar.
And
Yeah, I think the same problems here too. I don't know that this is entirely clear what Dr. Abishagar did. I guess it was is it the delay in sending him to Dr. Shavala? Is that the issue?
Here's the problem, Your Honor. There are several defendants treating over a 3 or 4 day period, putting different pieces of the puzzle together. Dr. Abishagar, and I apologize if I misstate her name, was responsible for the first day post-op visit when she noted abnormalities which should have indicated an infection, and instead of referring him or calling the doctor, she's an optometrist, calling Dr. Hines, the ophthalmologist, or referring him to an ER for evaluation, instead told him to come back the following Monday, which was 2 days hence. And the purpose of her evaluation was to assess 1 day post-op the surgery.
But the problem I have with this report, and maybe I'm missing it, I don't see that there's anything in the report that says the delay led to the loss of the eye or was somehow contributed to the loss of the eye. It just says there was a delay. And so I tend to agree with Ms. Drum again that that needs to be clarified. It's a little bit clearer than what it is on Dr. Shavala, but I'm going to go ahead and order that be supplemented within 30 days as well. Unless, Ms. Drum, you just want to drop it.
No, we asked that it be supplemented, that it be cured.
Okay. Anybody else?
Sure, Judge. Ryan Trammell for Dr. Hines. I just wanted to point out a couple of cases on the breach of the standard of care issue as to Hines specifically.
You're going back to standard. Can you bring up standard of care?
I
Sure.
will. Would you like for me to do it since I already have the report up, or do you want to do it?
That's great with me if you're willing to do that.
Sure. What page would you like for me to go to?
So, Your Honor, there's 14 pages. This is the only place on 14 that I see any sort of indication of what the plaintiff actually says Hines did wrong. We have this allegation that the infection is occurring.
Was Dr. Hines the original surgeon
He is the surgeon, yes, Your Honor.
who did the surgery?
The initial surgery, yes, sir. And there's a pretty expansive body of case law about these infection cases in the expert report context. And we see it frequently. I would cite the court to the Kelsey-Siebold case out of Houston, which is a spinal infection case. Similar situation where an infection occurs and the report states, well, there could have been unsterile instruments. There could have been an OR that needed to be cleaned. The court says that's not good enough. You need to actually state in what way the infection was caused by the unsterile environment. Here we don't have that. That Kelsey-Siebold case got sent back down and came back up on appeal with a supplemental report, and it was found to be sufficient once the expert concluded that there was evidence based upon an affidavit from the plaintiff that no one was wearing masks in the OR. So the expert was able to conclude more likely than not, infection results from people not wearing masks in the OR. Here we don't have that. The closest thing we have to a statement about what Hines actually did is on this page when it says that it could have resulted from unsterile instruments being used and the incision not being closed. It's the closest thing we have is a could have. And if you look through the rest of the report, the rest of the 13 pages, there is significant discussion of all the things that Hines did do. The report talks about how he applied sterile draping and that he did
I thought you were objecting to standard of care, but are you actually objecting to causation?
breach.
Breach.
I don't think it appropriately describes the breach.
Breach. Okay.
That's my actual objection. Yes, Your Honor. I
Response?
think there needs.
Your Honor, the standard of care for Dr. Hines was enumerated several times in the report, and that was to adequately seal the corneal incision he made. And the allegation is that he failed to do that, thereby creating a portal, if you will, for the bacteria from some unsterile source to enter into the wound and cause.
I will tell you my look at this report. I think it's okay, but I haven't read this other case out of Houston. Do you feel like it would make more sense for you to go ahead and fix this now if it somehow is not in line with what this Houston court says, or do you want to just kind of go forward with what you got? I thought you might want to just fix it all at the same time, but
how about this, Your Honor? I think this case is eminently distinguishable from the Kelsey case, which went up on qualifications, not standard of care anyway. But since we're going to redo portions of the report, I can probably get that massaged, so to say.
okay.
I'll be happy to live with it, and if it's appeal, let me put it that way.
So you on this one, then you go ahead and just declare it insufficient and you're going to supplement it or not?
We'll supplement.
Okay. All right. Ms. Hirschman, give me an order on this and share it with Mr. Grappelberg. Go ahead and make sure it includes the 30 days in there. Make sure at the beginning of the motion, it says that this was heard on March 7th, 2022, as opposed to on this day. Email it to my coordinator, Rhonda, as well as e-filing it and sharing it with Mr. Grappelberg and the other attorneys.
Yes, Your Honor.
Mr.
Your
Wilson?
Honor, may I ask for a clarification?
Sure.
I understood your ruling early on, but Mr. Grappelberg incorrectly stated that we did not object on causation or standard of care. It is in our motion. And the same thing that was pointed to with regard to Dr. Hines applies to the Kleiman defendants, where it says it could have.
Let's do all the same thing. So go ahead and just ask only I'm not trying to fuss with Ms. Hirschman, but only as the causation, not as to qualifications. Does that make sense, Ms. Hirschman?
Yes.
So Mr. Murphy's ruling will be in line with everyone else's.
Thank you, Your Honor.
All right, anything else, guys?
No, Your Honor.
No, Your Honor.
All right, thank you, guys. You guys have a good day, and get me the order by the end of the week, Ms. Hirschman, okay?
Yes, Your Honor.
Thank
Thank
you.
you.
Thank you, Your Honor.
Okay, I think we have one more case, City of Dallas versus Hector Convenience Store. You guys, Ms. Bishop, are you here for that?
I am here.
Are you with the City of Dallas?
Yes.
All right. Defense counsel, Mr. Bowers is not here yet, I guess.
It does not appear so, but I did communicate with him and I'm expecting him shortly, hopefully.
Okay. Well, Mr. Wilkins, are you here for the City of Dallas case?
Yes, I am, Your Honor. I'm second chair, though. Kelly Bishop is going to be handling it.
Okay. And the person on the phone, who's that?
Chris Bowers.
Okay. Well, Mr. Bowers, how are you?
Fine. How are you?
Good, good. It's been a long time.
Yes.
So let's get started on this. Let's go on the record on DC 212576, City of Dallas versus Hector Convenience Store, Inc. Council, make your appearances.
Kelly Bishop with the City of Dallas.
And Chris Bowers for Hector Store, Inc. and other defendants.
David Wilkins with the City of Dallas.
And we're here on a motion to abate. Is that correct?
That's correct.
Yes, Your Honor.
Let's go ahead and proceed.
I'm sorry, Judge. I was turning on my camera. I didn't get the second counsel's announcement.
Chris Bowers is for the defendant. David Wilkins is second chair for City of Dallas.
Thank you.
Go ahead now.
Chris, I'm happy to yield to you if you would like to open.
Okay. Well, it's not my motion, but I'm happy to. Your Honor, we have been working with the city to make repairs And there are a couple of unusual impediments in this case that don't exist in almost any other code case I can think of. One is that there's a title dispute. We believe a fake deed, fraudulent deed, was filed in the deed record several years ago. We have filed a separate lawsuit to clear title. I don't believe under the local rules that it was required to be in this court, but Your Honor, we would love to be in this court. If Your Honor believes that it is related, we have been unable to find the defendant. We don't know why this deed was filed in the deed records, but obviously clearing title is important because the city is asking my client to spend a lot of money to fix up this property. And why would he want to do that if he didn't have title? And he is very confident he has title, and that's why we're proceeding on that clear title suit. The second reason that this case is very unusual is that there is an existing sanitary sewer line underneath the building that is on the property. And the city believes that, or will not let my client obtain building permits or certificates of occupancy until that sewer line is moved. Your Honor, the sewer line is not recorded, and we don't believe there's anything that my client could have done in the exercise of due diligence to know that that sewer line was there when he bought the property. So both of those issues are huge impediments. Having said that, my client has the resources and wants to put this property to productive use and believes that it will never be put to productive use unless the city either agrees to allow the renovation of the building to occur over the existing sewer line, or will participate with my client in relocating the sewer line. And my client is willing to donate an easement on the edge of the property to allow the city to relocate the line. So that, Your Honor, those are the two reasons we're asking for an abatement of this very unusual code case.
Ms. Bishop?
Yes, the only thing that I would add to that is I am under the impression that DWU is currently working on a plan and implementing rerouting that sewer line. And that's something that Mr. Bowers and I have discussed in depth, but the city also does not feel like we can do much here until title is cleared and some other things have occurred.
So let me ask you this. So when is this case, is it set for trial at this point?
I believe we were set for a trial. I don't have that date in front of me.
Let me pull it up.
And Your Honor, I'm in the same position, and I apologize for the background noise, but I am in Taos, New Mexico at a ski lodge at the moment.
Well, you're having much more fun than we are, I'll tell you that.
I'm trying to, Your Honor.
Well, I hope you're enjoying yourself.
Doing my best. At my age, I just try not to fall down, and then it's been great.
That's great. Let me just take a look at this. Computer's kind of slow at the moment. You are not currently set for trial. So I guess my only concern here is just so you don't have a trial setting, so we're not under no particular rush. What is the status of the other lawsuit? Whose court is it in?
Oh my gosh, Your Honor. I do not recall right offhand the name of the judge or the court number. We filed that suit with about 3 or 4 months ago, and I just obtained an order from the court authorizing citation by publication, since we have this corporation that supposedly now has title, has nothing filed with the Secretary of State, and all sorts of searches that we've done. We can't figure out any way to serve this defendant or if this defendant really exists. But I believe we're the only other case filed in the Dallas courts under the name Ector Convenience Store. So if somebody has access to the network, we could figure out what court that case is in.
This is a suggestion. It's not necessarily, it's not a ruling yet, is my concern is just doing an abatement as this case could just kind of last forever. What if we do this? What if we put this on a 120-day DWOP, so you have, a good bit of time to try to work things out on the other case, hopefully get a default judgment and all that stuff. Mr. Bauer, you might want to go ahead and file a motion to transfer the case to my court, but you don't have to. If you get that issue resolved, it sounds like you're getting pretty close anyway, either in my court or in the other court. Hopefully that would provide you peace of mind, or your client peace of mind, to allow you to go forward. But I don't want to just have it out there forever. But by the same token, Ms. Bishop, I know the city is trying to make sure that this property is not fall into disrepair and become an eyesore and a blemish on the city. And so I'm trying to figure out some kind of middle ground here. How do you feel about that, Ms. Bishop?
I think in this particular case, it might be problematic because in working with DWU and the rerouting of the sewer line, that's what we're trying to do. We may be looking at 18 to 24 months on that issue.
And Your Honor, that's my understanding too, is that the city is trying to identify funding and other things like that to make that project go forward. And so I do agree that.
And let me ask this, maybe I'm not understanding this. The issues with with code compliance can't be dealt with until this sewer line issue is worked out. Is that right?
That's the city's position, Your Honor.
Yes.
I guess, why did you file this lawsuit right now?
I don't know. Well, I wasn't here when this lawsuit was filed, but I don't think that I don't think this city had all of the information at that time that we do now. We've discovered quite a bit in the process of litigating this issue. So we're privy to new information that we didn't have before.
And Your Honor, I do recommend some sort of a tickler system here, but I can assure you my client is losing money by constantly repairing the property when vandals break in, as well as annual taxes. So my client very much has an incentive to try to move all of this along.
And does your client feel like they can repair the property with the sewer line issue still in place?
My client would like to begin repairing the property now, but the city's position has been that they don't allow buildings to be over sewer lines. And now that they've discovered that they erroneously granted the building permit for this building many years ago, they feel that they should not allow renovations of the building while the sewer line is active and under the property.
Okay, so I'm not trying to fuss with you, Ms. Bishop, but on one hand, you're trying to force him to make repairs in this lawsuit. On the other hand, you're saying he's not allowed to make repairs because it's over a sewer line.
Am
I understanding that correctly?
Your Honor, I was the field attorney on the case. I've been working on this longer than my colleague or Mr. Bowers. If you'd like me to give you a little bit of background, I'm happy to do so.
Sure.
All right, so this property it was built in 1996 over a portion of an abandoned roadway that had a sewer line running under it. It's possible that at the time it wasn't discovered that the sewer line was there. It was at a time when the city was switching from paper files to digital files. In any case, in 2002, it was discovered that the portion of the lot on which it was built had never been platted and therefore was not a legal build site. In order to become a legal build site, an easement had to be granted for the sewer line. Therefore, the CO was yanked for the building, and there's been a basically 2-decade standoff where I think city departments were saying it's the owner's responsibility to pay for and move the sewer line. And the owner was saying, I have clean hands, the city should do it. So the suit was brought because the building has been deteriorating this entire time. We wanted to get everything resolved. Once the suit was filed, we entered into negotiations. We brought city departments in, and city departments, after looking at it, said, "You're right. We think we should move the sewer line. So we're going to move the sewer line." The next step will be then they have to replat the plat so that the two portions are all a legal build site. And then they can move forward with getting the permits for repair. But because the sewer line will take a while to move, they can't do parts B and C until part A is done.
So why was this lawsuit filed now then?
As opposed to 20 years ago,
As opposed to after the sewer line is moved.
Because nobody was looking at the sewer line and moving it until the lawsuit was filed. This was a part of our.
They didn't know the issue with the sewer line until.
Right, yeah. It was brought forward through the settlement negotiations, Your Honor.
All right, so Mr. Barry, you said there should be some kind of tickler system. The main way I do kind of a tickler system is putting it on a DWAP docket. I'm gonna just let you choose when you want to, because you'll have to be there too. So when do you want the next, within reason, when do you want the next DWAP?
Your Honor, I would suggest a 6-month tickler be established on this, and we would ask, or at least my client would ask that Your Honor accept a motion by hopefully a joint motion by submission, but in any event, a motion to extend and hopefully rule on it without a hearing.
Well,
assuming that we make a proper case.
Just put on a dismissal docket, so I can put you on a dismissal docket for 180 days, and then you can come back and just kind of tell me what's going on. I'd prefer to do it that way, because that's how we have 1,300 to 1,500 other cases at the same time, and giving a special exception to you guys about how we handle cases just makes it kind of complicated. So we'll just set you on a DWAP docket for 180 days. And if you want to send an email to Rhonda asking for an extension at some point, I'd be glad to look at that, but I don't want to change anything other than that. Does that work for you?
Yes, Your Honor.
Okay. We're gonna put this on a 180-day DWAP, Rhonda, and we'll go from there. Anything else, guys?
No, Your
No,
Honor.
thank you, Your Honor.
You guys have a great day, and we'll see you soon. Good to see you.
Okay,
Mr.
thank you, Your
Wilkins.
Honor.
Good to see you.